No, that's what it's called.
Are you on, Nathan? Are we on? Okay, we will reconvene the commissioner meeting at this time. So Jacob, we'll go back to you to explain where we are, please, with this, with the EDA agreement.
So when we took a recess, I know that Mr. Sherman was given some time to make some phone calls and discuss if this was during the break. I think guarantee is where it left off. For those who weren't here, when the meeting was held earlier, it's still the 5-year building construction phase period. I know there was some discussion about why it's not the length of the project for the full 20 years. But despite that request, the developer has not agreed to that. So what you have in front of you is what the offer on the table is today.
5-year guarantee. If not year 6, they do not. 1, we still have a written agreement. We would still have a written agreement that's signed by all parties. That's correct? That's 1. 2, at year 6 and on, if they do not, obviously there would be litigation with that. But also the tax would go to 30%. It's outlined 30% for them. Is that correct?
They have agreed to that. So what that means is that would be how their taxation would be handled rather than just whatever the state law is at the time.
Okay.
For personal property taxes.
Okay. All right. Very good.
And I think it was brought up earlier that there were some changes or suggestions about venue and jurisdiction, which have been agreed to, and changed back to Pulaski County. That realistically, if litigation filed, we're going to have a special judge anyway, and the venue is simply the same. And that has been changed.
In the northern territory.
Correct, the northern district as opposed to the southern district.
Really?
Well, I'll make a motion then to accept as presented.
Hold on, before you make that motion, Mike, you need to make it in the form of adopting a resolution authorizing the commissioners, and Teresa, I'll need to get the specific resolution number from you later. But Mike, if you're gonna go ahead with this, yeah, you need to adopt a resolution to be named later, authorizing the commissioners to execute the agreement. And you should have a copy in front of you.
I make a motion to accept as Nathan presented.
Approving an agreement for economic development with Mammoth Grazing Lands LLC and Mammoth Pastures LLC and other certain matters in connection thereof. Is that what you're referring to, Nathan?
Yes.
Yes. I will second that. Discussion, further discussion.
I've got a couple other areas that I would like to
Please.
hash out. On payment of county expenses, number 7 in the concerns that I listed to you. How are we, Nathan? I know you have discussed before the land that's going to be assessed. And I've heard 2 different numbers. I've heard 35% of the land will be assessed that's in the solar project. And I've also heard 60% of the land will be assessed. And it was also in the Baker Tilly report. They mentioned that as well.
Give me one
How
second,
do you,
please.
what are you basing those numbers
Give me
on?
1 second to find
Okay.
that section.
Is this a question in this document?
Yeah,
Maybe?
yeah, it is somewhere in there, yeah. And so I'm just gonna read what I've got down, might help you a little bit more. Okay, so Baker Tilly, in their report, was only using 60% inside the fence, or 5,265 acres of the 8,776 acres in their calculations for solar assessed value. But they also state that only 35% of that 60% will be used for solar, or 1,843 acres. Which value is truly being assessed? The 5,265 or the 1,843? And can that number be documented in the EDA so there's no confusion?
And just so that I don't get percentage, there, paragraph 9. I know you have your
I've got
numbers,
papers
right?
everywhere.
That's the title that says assessment of real estate other taxes.
Yes,
Okay.
yes, that's correct.
Okay, so here we go, section 9. Excuse me one second, Jenny. I gotta see if I printed something wrong from what I sent you in the email. Because as I recall, based on guidance from Rick, we replaced the references to solar panels specifically to the fence. I don't think we can.
Say that again,
I'm sorry.
Nathan, I didn't hear you.
I'm trying to figure out where the verbiage is, but based on legal counsel from Barnes and Thornburg, the version that I emailed you all, it removed the reference to panels and replaced it with fence. I don't think we can put a specific acreage in because that may vary when they actually build, but rather than the uncertainty of or lower number of panels, I think the final version says that anything within the project fencing will be assessed, notwithstanding any guidance from state law or state agencies to the contrary, at the solar base rate. Yeah, unfortunately, I don't have,
I don't have that
Yeah.
written anywhere.
that's what I said, I'm looking up, like, I'm trying to figure out,
All it says is that it will follow the statute, the assessment
let
guidelines.
me see if I can pull up the one that I sent out to you all to make sure I didn't print something incorrectly.
I think this one.
Nathan, are you able to allow him in, please?
Not without shutting down the YouTube or pulling out the other computer.
Are you able to go on the phone? Put the speaker up there.
Sorry, he said he had other things. I didn't know when he would be available.
That's all right, it's just a huge difference, and.
Right, no, I agree.
Both of those in there, so we don't know which one we're gonna be. And you've thrown out the number 60 million and 85 million,
Right.
but I don't know how you arrived at those numbers.
Those numbers are both based on Baker Tilly's assumption of 5,200 or whatever acres.
But then why would they throw in 35%?
That I can't answer.
It just depends on what gets built.
Rick, are you able to
Here
hear
we go,
us?
sorry.
Are you following the questions that are being asked concerning, the assessed valuation inside the fence, outside the fence, solar panels, et cetera? Or when we classify that, when that moves from farmland to solar?
Yes, I think there was some, I did not hear the question, but I know there was an earlier question about whether the language in the previous draft of the agreement of land under the panels was the appropriate language. In the statute uses a different term, and we changed it in this most recent draft of the agreement. I'm trying to find the section right now. But ultimately, what is assessed is going to be dictated by state law and the assessor's annual renewal. So, in terms of things being inside the fence or outside the fence, I mean, the way it's assessed now, my understanding is what's inside the fence is typically used in solar property, but the statute uses a different term, so we just inserted the term directly from the statute.
So Rick, I don't know if you can hear me, but you mentioned that it was changed in the newest draft, but it was not. It still says assessment of land underlying solar development projects. I believe, I have to find my correct language. The correct language in the state statute is different from that.
Jenny, which paragraph are you reading?
Oh, I just shut my.
Sorry.
Look at page 6.
Okay, page 6, number 9, assessment of real estate, other tax relief. And state code, I know Teresa, our assessor, has indicated as well that the state refers to land inside the fencing, but I do not see that in Indiana state code at all. All I see is the land underneath the fixed property of utility grade solar energy installation facility. But it has not been changed yet. I was told that it would be, but it has not.
Yeah, we did change it to, I'm trying to find it in here, I'm sorry.
Do you guys have it changed on page 6? Or does it still say land underlying solar development projects?
Was it in this paragraph there? And I know there's a 9, A, B, C, et cetera.
So I know that I made the change based on,
In accordance with the assessment statute, the parties agree that First Along project is operating the land portion of the fixed property of the project, which is the land portion of the fixed property of the project is what is in the state statute. And that's what's defined as the land will be assessed at the solar land base rate.
It's not consistent then with what is in our current agreement.
I don't know if I printed the wrong PDF because I know that I made that was on my list of changes.
This is the one, I just printed it off this morning.
Right, and that's the one I sent you is what I'm saying. I may have sent you the wrong PDF version from my files, but
It's in the fourth line of section 9.
Section
It
9.
should say that the land portion of the fixed property of the project.
yes, that is the language that is in there, the land portion of the fixed property. I think Jenny's,
And that's what's defined as quote unquote land that we assess as the solar base rate. And if you look at the solar base rate statute, it speaks of the land portion of the fixed property of the project.
Then can we make it consistent with what is 3 lines down from that, assessment of land underlying solar development projects? We should be consistent in that language at minimum.
Yeah, we can change that, in 3 lines down for the definition of land.
Jenny, I see what you're pointing
You
out.
see what I'm looking at?
Yes.
3 lines down, yeah. Yes.
Where's that, Sarah?
It starts with this, if you have the defined term land and you go down 3 more lines, it says land. It says assessment of land underlying solar development projects. So section 9. Ninth line. Instead of land underlying solar development projects, we can change that to the land portion of fixed property of the project, which would be consistent with the definition of land that's used earlier. I don't have a problem with that.
Okay, so we just need to make that line 3 lines down. We need to align that with the first instance.
Okay. and
Yeah,
then,
I'm sorry. I think when I made Rick's changes, I made it in one place and didn't realize there was a second one.
I think this is what we meant. Yes? Again,
As long as that.
Yeah, I will make sure that the final version has that swapped out.
And then back to Nathan, the 35% versus the 60% of land used for solar assessed value. Which one is it?
So
where is that?
Okay.
I'm just-
It is in, it goes with the Baker utility report when we're talking about the assessed value, but then that implicates our economic development agreement because we need to understand, are we assessing 35% or 60%? I think we should know that before we sign an agreement.
Rick, do you follow that? Rick, do you follow that?
I'm sorry, I did not catch that.
Jenny had a question about delineating whether we were assessing at 35% or 60%, and highlighting that specifically in the section of the agreement. Are you there, Rick?
Yeah, I'm looking. So you're saying in section 9?
Yeah, so I believe it's under the assessment paragraph.
I think, and Jenny, please correct me if I'm wrong, but I think what I'm understanding, like how this, because the percentages don't show up in this, in the art. It is, so if I understand correctly, the 60% or whatever exact number is reflective of that, is the same as that 5,200 acres or so,
Correct.
which is what is anticipated to be within fencing. Whereas that 35-ish% reflects the area inside of the fencing that actually has panels or other equipment over it, as opposed to any setback spaces between that sort of thing. So I think, Rick, if you can hear me, the ultimate question is the language you have had us use there, the land portion of the fixed property, is that synonymous with land within the fencing, or is that synonymous with land under panel coverage?
Inside the fence.
I understand that. My concern is that Baker Tilly has thrown in 35%. And if that is not specified in this contract, then at any point, the developer could come back and argue it's 35%. And we're significantly reduced in what we're going to be assessing. So I think we got to make sure that this is clear from one document to the next to be sure that there isn't wiggle room by a developer to pay less. And I know we're having issues right now, getting the information on the first Mammoth project, as far as maps to be able to understand what's going to be assessed. And I just think we're opening up, we're just exposing ourselves to a lot of gaps right now. We don't, and unfortunately, we don't have the first one to base this on. If we had collected the taxes on this first project, then we'd have a much better feel for what we're negotiating going into this second one. But without, are they gonna come to us sometime here in the next several months and say, no, we're gonna litigate that? Because based on the contract, they can. They can challenge the assessed value of all of this acreage. And we're kind of jumping into another project before we've had a chance to see how this first one's going to pan out. So that's my concern.
I'm not calling it 35% as an assumption.
Yes, it is.
It's not an assumption, it's what's stated in their report.
So is Baker Tilly's,
The acreage of their site, the acreage of their site is not going to change. The future, and once they adopt, it's not going to be used for the solar farm themselves. So now their solar portion of their land is now 60% of the property that they own. And I'm not sure why it is what it is. When Steve uses solar by law, so you have to have solar land basically applied to it, what this will be otherwise assessed.
But I think to avoid any dispute, we need to clarify that in the EDA.
I may have something, I will defer to the lawyers on how these relate with each other, the language in the EDA versus this, but as part of the confirmatory resolution that the council passed, in order for it to be valid, the developer has to agree to the terms of Pulaski County Resolution 2021-06 pertaining to various clawbacks and provisions that the council has adopted for tax abatements. And one of those provisions is that while they have the right to request the assessor review an assessment of any parcel for any human error, they forfeit the right to appeal the annual assessment of any and all parcels benefiting from such deduction for the life of such deduction. And this is something that every solar developer thus far who has received a tax abatement has signed, that they are not allowed to file a formal appeal on their assessment.
That's not what I read in there. I mean,
Well, that's why I said I would defer to the, there are two documents that might be read.
But it also says, I think it's in 9B at the top, page 7.
9B, top of page 7.
Last sentence, as such, the developer is not to contest or to appeal any determinations made by the county assessor or any other county entity upon provisions of evidence of such determinations or made in strict compliance with permit laws or regulations.
So as long as the assessor's office can show that its decision, its determination is based on prevailing law, and they just didn't say, I want to screw the company, so we're going to call those acres over there solar, even though they shouldn't, they can't appeal. Is that?
Yeah, basically, we're going to follow the assessment statute, and if the law, if the assessment statute is followed, they're not going to be able to appeal. Which, that's not, and I would just say, just having looked at a number of projects that have nothing to do with renewal, and just doing tax abatements on all kinds of, that's a very common term, is that if you're going to offer abatements, you're not going to give somebody an abatement and then later on say, oh, now we're going to appeal. So, I mean, that's not just renewable energy, that's a lot of abatements.
I understand that. I think we've got a loophole if we don't specify in the EDA that it is 60% everything inside the fence. I don't know, I mean, for the county's protection, I would want that in there.
the Baker Tilly report, is that a binding document? Or was that just a guiding guiding information for the county council.
Well, I mean, the assessment statute is what's binding. I mean, that's the law is.
And that wasn't the big facility.
Right, and my question, or one concern I would have is if we're putting in 60% in the actual contract itself, and we can change in law. I don't know if that would have a positive or negative effect on the county, depending upon what the law would change. I don't know that anybody could say what would happen in the future. But to me, I think, and correct me if I'm wrong, Rick, the reason for the language that says that they're going to follow the current assessment statute is so that at the time of the assessment, you would just simply apply the law. You're not locking yourself into a certain percentage because that may change over time. Is that correct?
Yes, and the percentage of the site that's used for solar could change. It could be a higher percentage of the site.
So if it was a higher percentage, then if you have something like 60% in a contract, you could actually end up shortchanging the county in that situation. Is that right? That would be my thought.
Right.
But, okay, Jacob, don't we have the maps and everything that goes along with this and the parcels? So how are we stating that this could change, because it really shouldn't?
No, I'm saying if the law changes and the percentages change,
Sure,
up or down,
okay,
that's what. So I guess what we're talking about is if the percentage will increase above 60%. If it's 80% or 70% or anything like that, then if you put 60% in the contract, you're binding yourself to 60%. Otherwise, perhaps that's more. And I realize there's a lot of speculation because we don't know what the law change would be. I mean, if we did, I could take a lot more money.
Yeah.
You know.
well, so, I mean, so long as this language is commensurate with the language in state code.
And I think the benefit of the county is the inability to appeal it.
Yes, I agree with that.
Which is, that's.
Reimbursement of legal fees. We've had issues with that in the past. The county has now received $120,000 from Mammoth Solar for their project. As was stated in the contract, it was to be paid to the county. So to avoid that moving forward, I would ask for a couple different options, either a flat fee or based on invoices at possibly 105, 110% to include administrative fees, because currently our departments are doing a lot of work and they're not being reimbursed anything for administrative fees. And it's taxing our departments. So number 13, yeah.
That's not, you're not referring to the fees for
Decommissioning.
paper and like stuff, you're not other administrative costs.
No, I think she's talking about those fees.
I am.
So, yeah, she's,
The reason I ask is because there is a separate.
so there is a separate agreement specifically for this agreement. But sections 26 and 27 of this agreement pertain to the decommissioning agreement, road use agreement, and drainage repair. 27 requiring those, and 26 addressing payment of fees.
Right, so I am talking about number 26,
Yes.
right, making payment of county expenses, professional fees, that we need a way, either invoicing.
So I did add language specifically regarding invoicing to make, now, none of us have discussed with the developer any sort of administrative fee on top of that, but as it's currently worded, these payments shall be made pursuant to invoices reflecting all such incurred costs and provided by the county to the developer within 30 days of receipt of such invoices by the developer.
Do you?
So that is in there. It's just a matter of that.
I would recommend an administrative fee, we're taxing our departments, and there's no reason not to have an administrative fee put in there. So I would,
Does the decommissioning agreement, road use agreement, drainage repair agreement take place after the application is filed?
I don't know if it has to take place after or parallel, but they all have to be executed before Carla can issue the building permit.
Normally they're done at the same time. Or shortly before, I mean, generally.
It should be done before.
Because most of the time they're contingent on passing the road use
Yeah.
or whatever, in order to do it.
Have you seen that, other agreements, Jacob?
Yeah,
Or
it's pretty customary. I mean, certainly Rick would be able to speak to that as well.
Often your zoning statute will ordinance will require that you have tenants agreement certain responsibility to require getting it through permit.
my,
Isn't it 90 days?
my point, Jimmy, is, Mike and Jacob, is that there's a fee along with the permit fee. So that's why I was asking that question. Is it customary to put a fee in for, as Jenny was asking?
Actually, that's a good point, Don. I think what the Plan Commission commissioners did earlier this year to change the fee schedule contemplated that. In addition to the $15,000 base fee, the $1,000 per megawatt fee, and whatever the decommissioning bond or whatever at the end, there was a specific $10,000 fee to cover county costs in the development of these agreements. That is in there. So when you guys approved the APC's recommendations that Carla brought to you, you approved going from $15,000 flat fee plus third-party costs plus 5% to $15,000 application fee, third-party costs plus 10%, $1,000 per megawatt, and a $10,000 agreement development fee that covers exactly the concern you're raising. So that will just be covered in their building permit fee rather than when they pay for these charges. But that is addressed by the development fee schedule that you approved earlier this year.
Those are the items that I have, hold on. Does any of the, what changes, ma'am, if you can address this? If you become a IPO, you go with the IPO, does that change anything as far as this EDA agreement?
No.
Pardon me?
No.
Changes nothing? Okay. All right. I don't have anything else. The only thing because I know you're gonna put this to a motion, probably in a vote.
It's been motioned in a second so far.
Oh, okay.
For discussion.
I did not, council went over this a couple weeks ago, they voted for it, and we were asked to go through and bring up our concerns, which I brought up several. But Jacob, you didn't reach out to me until 9 o'clock last night to go over any of this, and my fear is that I have not had a chance to go through and make a comparison between this, which I know is still very incomplete. And I would definitely want to make sure that this is gone over. And I mentioned before, I want the complete agreement in front of me before I would consider signing anything. I'm fearful that there may be more things that we're missing. This has been very quick.
Jenny, are there specific things you don't have in front of you that you?
No, it's a matter of time to go over it. I've not been able to, Mike, have you read the whole thing cover to cover?
I won't live that long.
So, that's concerning to me.
That's all right.
Well, I also, Jenny, I understand your point. I also believe that, we hired Jacob and we have Nathan, but also Rick to help us through this too. There's a lot of wording, legal wording. And I think that, what I've asked Rick was, and Jacob, is from a legal standpoint from the county, is this good for the county? And so Rick, I asked you that question now, and Jacob, I asked you this question now. Based upon this agreement, is it good for the county?
Rick, if you'd like to go first.
Yes, I feel this is strong. The economic development plans provide significant cash and flexible dollars. And I think the amount of those payments is consistent with what I've seen around the state. And I think the agreement has the appropriate protections. So I recommend approving the agreement.
Jacob?
I would join in Rick's comments. A lot of time was spent reviewing, negotiating, multiple meetings. I also think, to further Rick's comments, anytime you're negotiating a contract, at least from an attorney standpoint, I always view it as, what if everything goes wrong? What if they default? What are the remedies available? And the remedy in this particular case is greater than just regular taxation of the personal property. And so, to me, I think that, I know there were some terms that the county didn't like this season, but the developer did not agree to, and that's kind of how these negotiations work. But I think all in all, it's a good agreement, and I'm comfortable with it.
Nathan, you made a comment.
Yes, ma'am.
The county will still receive the value of the tax levy with or without the abatement, but we won't get the bonus funds without the EDA and the abatement.
Yes.
Okay. I mean, that concerns, so when we're talking about we're gonna get a better deal, you've
So-
mentioned the bonus parts are not gonna come without it.
Right, we don't get the ED payments without the ED agreement. We just get taxes for 5 years.
So so is it as great as is it more or equal to what Jacob is saying, or are we possibly looking at less?
Let me explain that. So I don't want to go on like a 30-minute explanation
No, you
of
don't
it,
have
but I will.
to. Just, you made that statement.
Yes, so what I'm saying is, whether or not this project happens, the Pulaski County and all of the affected taxing units, so the 4 townships, the 2 school districts, the library district, they have a maximum property tax levy every year, and it grows by a set percentage approved by the state, typically around 4%. If no investment happens in this county this year, and nothing is depreciated, the net assessed value is exactly the same from one year to the next, then everybody's tax bill will increase by 4% to reflect the increase in that levy. If if nothing changes but one project, and then let's say it's the solar project, and it brings all this new assessed value, then the county will, oddball funds like the cumulative capital development that are rate driven rather than levy driven, will see an increase in revenue based on that. But the bulk of the funds, because they are levy driven, this project will pay enough taxes to fill that gap from year A's maximum levy to year B's, like that 4% increase. And then it'll pay more that will just push taxpayers' rates down, which is good. We want to see rates go down for people. We want to be more cost effective. We want a lower cost of living. But getting, $1 zillion of assessed value does not give you 1.25% of that $1 zillion in new tax revenue. We are affected by the tax levy, by the maximum levy, except for the few funds that are rate driven. So what I was saying in that text is that either way, project or no project, abatement or no abatement, the county is going to collect its property tax levy. It is just a matter of what percentage of that levy the new project is paying versus every other taxpayer. But if we ask the developer to pay their full tax burden for the 5 years that they have depreciable assets, taxable assets, instead of the economic development payments, we're not necessarily going to see $28.5 million in net new revenue for the county. They're going to pay 28.5, but the county and the other taxing units are going to get the proportion of that covers each year's maximum levy growth, while the rest of it will push tax rates down. Even with the abatement, because they have so much land, even if it's 35%, they're going to push tax rates down just by that land reclassification. But we're also going to get the bonus money of the $5.75 million for 4 years and then 2.5 for 16 years. So that is what that meant.
That excess would still go to the state as opposed to a solar developer.
Yes.
So the state would still be making.
Well, I mean, the state distributes it, but
The
yeah.
state would still be receiving that money as opposed to giving it to them.
But we don't get more money except in the levy rate-driven funds just because we have a massive increase in assessed value. We just see our rates.
My final comment, I still believe this EDA offers more protection to the developer and puts the county at risk. Without that guarantee, we're still at greater risk. It's an incomplete EDA. I asked for a completed EDA to be presented to me, and we're kind of all over the place right now, so.
What we're voting on is this resolution.
That resolution which authorizes the commissioners to execute the EDA.
Thank you for the question. I thought there was, thank you. I believe there was a lot of discussion and important points, so thank you. Those in favor of passing we have a motion and a second to approve the Board of Commissioners, Pulaski County, Indiana, agreement for economic development, which has been discussed. Those in favor say aye. Aye. Those opposed?
Aye.
Anything else, Nathan?
Not for me.
Jacob? Rick, thank you for your help. We have just a couple of rundowns, if I'm right on this. 7:45 on the 22nd, we have a spatial meeting, and the only thing on the agenda of substance will be approving claims to help with the paying process. From there, we have an executive session during that time period, and we will not meet again unless there's an emergency until January. I'd also like to thank the Highway Department, the County Highway Department, for all their work during this unusual amount of snow and weather we've had in November and December. So at this time, we will have an opportunity for any public comment. We ask that you provide your name and residence. We ask that you only speak one time and limit your comments to 2 minutes.
My name's Bob Arger from Risk Grove, and I would just like to ask the committee a question. I mean, you've got one guy that is in charge of everything. I mean, he's in charge. He was the head executive of the courthouse, and he was bringing the solar in and asking for their tax abatements twice. And he comes back and asks for something else. You guys never turn him down or never, I mean, as long as it took the day to talk this over, you should know there's something wrong. There was a team of lawyers that put that together. Not just the county lawyer or something. That was a team of lawyers, and they know what they put down. I was in the steel workers. I was on the executive board. I dealt in contracts. I went in contracts with And I can tell you this, that somebody is smart. And they know why they put those words in, because we went through this before. As a steel worker, I can tell you, if there's a word in there you don't think is right, there's a reason for it. I'll guarantee you there is. And you're following somebody that's not even in our county, don't even live in our county. There's never a no. Why is there never a no? I'm just asking. It's just unusual. There's never a no.
I appreciate the comments. We were working with our attorney as well as Rick Hall, the attorney for Thornburg, that was also representing the county. And the gentleman.
I just think about our county. I love our county, and I don't want it to fall apart, but it is. And we're not helping it.
Thank you.
I will say in response to that, we're working with the attorney at Barnes and Thornburg. I've not had any contact with Barnes and Thornburg at all. And I heard from our county attorney last night at 9 o'clock on this EDA agreement. So I don't feel like that's fair to me as a commissioner to be asked to vote on something that quickly. I don't see any, there's, in my opinion, there's no excuse for that. I didn't appreciate a phone call or a text at 9 o'clock last night asking if I wanted to talk. I had an hour and a half left. I didn't finish going through this until 11 o'clock, and I still didn't go through it with a fine-tooth comb, and it was put to vote this morning. And if the county has learned anything, it should be not to shove projects and agreements through like that. It's unacceptable. I had 2 weeks that, Nathan, you did respond to me. I don't understand how that can be. Very unfair as a commissioner. And I did not have any contact with Barnes and Thornburg at all.
Anyone else?
I'm not going to walk up there, Chair. Jay, I would hope you bring it to a vote, abolish the board, the ADA Western Board, we would spit on, and then ignore it. And your director says she's the director now, whatever. She does not do her job, she's a failure. And I would hope you guys consider that when you do appointments. She's a failure.
Thank you, Terry.
Thank you.
Anyone else?
I make a motion to adjourn.
Second. Those in favor, aye?
Aye.
Yep, I got.
You might as well take a nap.
That's what we did.
Very frustrating. You didn't read the agreement.